Hi guys, I hope you all are doing well. This is Sejpreet Kaur and you're watching Legal Bites. In today's video, we will be learning about the legal maxim Actio Personalis Moritur cum persona. In this video, I'll be looking at the meaning and origin, the application of the maxim, a few exceptions to the maxim, a few illustrations, and last but not the least, some important case laws to understand the maxim better. So let's get right into the video. Let's take a look at the meaning and origin of the maxim Actio Personalis Moritur cum persona. So Actio Personalis Moritur cum persona is a legal term of Latin origin. In order to understand the meaning, we'll break down the maxim into 5 words and understand the English meaning of them. So the first is Actio, second is Personalis, third is Moritur, fourth is cum, and fifth is persona. Actio means action, personalis means personal, moritur means death, cum means with, and persona means person. So, the term literally means a personal right or cause of action of the person dies with the death of the person. So now that we know the literal meaning of the maxim, Actio Personalis Moritur cum persona, let's understand it from a legal perspective. So there are certain causes of action which cannot be brought after the death of the person, which means the personal right or the cause of action dies with the death of the person, and the same cannot be executed upon his legal heirs or legal representatives. Now let's move on to the application of the maxim. So the maxim is generally applicable in cases of personal nature contracts. It is assumed in such cases that with the death of either of the parties, the contract will come to an end. Examples of such contracts are promise to marry or perform at a particular function. Basically, contracts which involve a personal skill are known as personal nature contracts. So next up is exceptions to the maxim. So there are 2 exceptions to the maxim. One is contracts and the other one is unjust enrichment of tortfeasor's estate. First one, contracts. So apart from the contracts of personal nature or contracts which involve personal skill, the other forms of contracts do not come under the maxim Actio Personalis Moritur cum persona. And in such contracts, if either of the party to the contract dies, the legal heirs or the legal representatives of the dead party can be made responsible for the execution of the contract. Second, unjust enrichment of tortfeasor's estate. So in a scenario where a person has wrongfully appropriated the property of another and before the property could be recovered, the person dies or passes away, then in this case, the person whose property has been wrongfully appropriated will have the right to execute the same against the legal heirs or legal representatives of the dead party. So now let's take a look at this illustration. So there's A and there's B. A is a famous singer and B was going to get married in the month of December. B contracted with A to perform at his reception ceremony. B's reception ceremony was in December, right? But in the month of July, A met with an accident and passed away. So now B cannot execute the contract which he made with A against A's legal heirs or legal representatives, since this is a contract of personal nature and the maxim Actio Personalis Moritur cum persona will be applicable in this case. Now let's take a look at this case. It's the case of Hambly versus Trott. This is known to be a very famous case since it is one of the founding cases for the establishment of this maxim. So in this case, the court held that if a person takes any property from the plaintiff and derives unjust benefit from the same and passes away before the property could be recovered, the plaintiff will have a right or cause of action against the legal heirs or legal representatives of that dead person. The second case is that of Girija Nandini and others versus Brijendra Narayan Chowdhury, and in this case the court held that the maxim of Actio Personalis Moritur cum persona has limited application. जो हमने पहले पढ़ा, इसके दो exceptions होते हैं, that is contracts apart from the contracts of personal nature and unjust enrichment of tortfeasor's estate. So this is it for today's video. Thank you so much for watching our video. Please do not forget to like, share and subscribe to our YouTube channel. Additionally, there is an article on the same maxim, the link to which can be found in the description box below. Thank you.